Let me ask you this. What if I told you that according to one pretty out there theory, almost every financial agreement you've ever signed, think car loans, mortgages, isn't what it seems? The source material we're diving into today outlines this really complex idea that there's a hidden system of trusts that really governs all of commerce. So today, we're here to explain what it calls new trust technology. Yeah, the source material does not mess around. It kicks things off with this incredibly powerful, almost provocative statement. The claim is really simple. If you don't get how this hidden system of law works, well, you're controlled by it. But if you can master it, you're the one in control. And that really gets to the heart of this whole theory, doesn't it? What if the papers we sign, the contracts we enter into, aren't what we think they are? The source is claiming there's this invisible structure, a secret relationship that's set up by default to work against us. So before we can even get to the solution that this theory puts forward, we've got to break down the problem it says exists in the first place. Let's start with the basic ideas that supposedly hold this whole hidden system together. Okay, the first key concept we have to wrap our heads around is something called a legal fiction. It's basically an assumption the legal system makes to get the outcome it wants, even if that assumption isn't literally factually true. The source says to think of it like a mask. It allows the rules of the game to change, even when the words on the page look exactly the same. And this leads us straight to the nature of contracts themselves. And, this is where the theory makes a really bold claim, that true common law contracts, the ones based on a genuine exchange of value, basically disappeared back in 1933. What we use today, the source says, are colorable contracts. They look like contracts, they feel like contracts, but they're supposedly just a disguise for something else entirely. And there it is. That's the core claim of this entire theory. It argues that every single time you sign a major commercial agreement, you're not just taking on debt. You are, according to this source, unknowingly creating a trust. So how does a hidden trust suddenly become a system of control? If they're being created without us even knowing, what's the mechanism? This next part digs into how the system supposedly interprets our actions, or maybe more importantly, our lack of action. Well, according to the source, there are two types of trusts in this game. You've got an express trust, which is one you create on purpose, you set all the rules. But then there's an implied or construed trust. The theory argues this one is the default. If you don't say what you want, the court steps in and defines the relationship for you. And this presents what the theory calls a huge fork in the road. Path number one is silence. You do nothing, and the court just construes the trust on its own terms, which usually means you end up as the debtor. Path number two is action. You proactively express the trust, defining the terms yourself and seizing control of the relationship. Okay, so if the big problem is this trust that gets created automatically, what's the fix? Well, this brings us to the main idea from our source, New Trust Technology, or NTT for short. It's laid out as a framework for taking back control by actively defining these hidden trusts on your own terms. Now, to use this technology, the source says you got to know the basic anatomy of a trust. There are four absolutely essential building blocks: the parties involved, a specific piece of property, they call that the res, and then the intent and the purpose, both of which are defined by the person who creates the trust. First up, the grantor. According to trust law, this is the most powerful player on the board. The grantor is the creator, the one who puts the asset into the trust in the first place and gets to write all the rules. Next, you have the trustee. This party holds the legal title to the asset, but their job is pretty straightforward. Just manage it according to the rules the grantor laid out. They're kind of like the administrator. And finally, there's the beneficiary. This is the person or company that the whole setup is designed to benefit. They're the ones who get to enjoy the profits or rewards from the trust's property. Okay, so that's all the theory. But what does this actually look like in practice? How would you apply it? To make it real, our source gives us a case study focusing on one of the most common financial agreements out there, a mortgage. So here is the step-by-step remedy the source proposes. Okay, step one, you re-express the trust that was created when you closed on the house, and you assert your role as the grantor. Step two, you reappoint the parties. You actually designate the bank, which is already the beneficiary, as the new trustee. Now this next step, this is the linchpin. The bank is now wearing two hats. It holds the legal title as the trustee, and it holds the beneficial title as the beneficiary. According to this theory, when those two titles merge into one party, the trust automatically terminates by law. So what's the final step? The trust has to be settled, which the source claims completely resolves the account.
So this all leads us to the final, and according to the source, the single most critical piece of this whole puzzle. The key to this entire process isn't some complex, drawn-out legal battle. Nope. It supposedly all comes down to one simple action: the way you sign your name.
And here's the core tactic. The theory claims an unqualified signature, just signing your name like you always do, is an act of silence. It lets the system define you as the debtor. But a qualified signature, where you specifically add your role, like signing, by grantor, is an act of expression. It's a declaration of what you intend, supposedly putting you in the driver's seat of that trust from the very beginning. And that brings us to this final thought from the source material. It's a fascinating, if pretty unconventional, theory. It completely reframes our entire commercial world as just a series of hidden trusts, and it claims the key to unlocking it all lies in the simple act of a signature. It definitely leaves you wondering, what is the real nature of the agreements we sign every single day?